All right, very good. All right, so welcome to the June meeting of the PRC. We have a few regrets regarding today's attendance. So John will not be here, Howard won't be here, and Peter won't be here. All right. So the first item of business is approval of the minutes for the meeting. So can I have a motion to approve the minutes, Stefan, and seconded by Irving? Thank you. All in favor? Thank you. We don't have, as the privilege agenda, we don't have minutes for last month's meeting or for the previous month. Peter has been tied up, so we'll have to catch up with that. I would think realistically over the summer. News and announcements. We don't have anything new in that regard, unless someone wants to bring any news to the attention of the meeting. Okay, business arising, so updates on the parliamentary committees. The first one is Justice and Human Rights. Again, because Howard is away, we don't have a report in that regard. That moves us into the Commons, Public Safety, and National Security. That's Rob. You'll note in the agenda that I attached Rob's report for last month, so thanks for that, Rob. And since Rob is here, can we have your report for this month?
Okay, thanks, Miles.
Sure.
So we CQ had 8 meetings since our previous PRC meeting. I'll start out with May 23rd. They began by continuing to study the growing problem of car thefts in Canada. They had the Minister of Public Safety, Minister of Transport there, and some public servants from CBSA, Department of Public Safety, Department of Transportation, RCMP. They got into more, instead of really focusing on that or getting into that, they instead got into continuous points of order and disagreement on how to proceed. There was eventually they took a break, and then the ministers left, the chair resigned, and then they came back, elected a new chair. So the new chair is Ron McKinnon, a Liberal from BC. And that pretty much captures May 23rd. May 27th seems like perhaps I'm not sure, maybe by electing the new chair, they seem to be able to move forward a little bit, although there seem to be just partisan kind of things coming up the way they're proceeding in the previous meeting. In any case, they finally reached some level of agreement to how to proceed with the work over the next weeks. So they agreed to draft a report on the victims of crime, agreed that the draft report on victims of crime, security reclassification, transfer of federal offenders would be distributed immediately to the committee members. That had been a point of contention in the previous meeting on what they were going to do, or how that report was going to come out and when, etc. So that was one thing they agreed on. Then they agreed that the analysts would prepare a draft report on the growing problem of car thefts in Canada and distribute it to the committee members. And they agreed to study a study of Bill C-70, which is an act respecting countering foreign interference. The study of that be initiated on May 30th. And then in the second part of that meeting, an act to restrict young persons online access to sexually explicit material. It's Bill S-210 that came up. The focus around that was mainly around age verification and how that could be done in order to help in this on that topic. And the definition of pornography versus sexually explicit material was another topic of discussion. but mainly it was about age verification on websites and how that could be done. Then we're on to May 30th. So that's Bill C-70, an act respecting countering foreign interference. It's CSIS there, Department of Justice, Department of Public Safety. So this is commencing consideration of that bill on that day. I picked off a few things. The bill creates 3 new offenses in the Security of Information Act. One being a general foreign interference offense. The second being a commission of an indictable offense for a foreign entity. And the third being interference with a democratic process. They mentioned possibility of increasing the penalty for a commission of a preparatory act from 2 to 5 years, and creating a new sabotage offense with a maximum penalty of 10 years. So that was some of the information I picked off that could be of interest to our committee. June 3rd, they continued on with the study of Bill C-70. They had various non-government witnesses there. The Canada-Tibet Community, the Sikh Organization of Canada, Civil Liberties Monitoring Group, and several individuals. There was no evidence available for that day. Same with June the 4th, no evidence, but there were several individuals who appeared. And on June 5th, more individuals, as well as the Business Council of Canada, Canada-Hong Kong Link, and the Hong Kong Watch. June 6th, CSIS, Department of Justice, Department of Public Safety, National Council of Canadian Muslims, Office of Intelligence Commissioner, Privy Council Office, and the RCMP. And on June 10th, CSIS, Department of Justice, and Department of Public Safety. So several meetings on Bill C-70, but no written information available to look at for me. So that concludes my spot on the agenda. Any questions?
Yeah, thanks, Rob. I just a couple of points. I noticed you mentioned 2 enactments that we don't have in our bill section of the agenda. So C-70, would you recommend that we incorporate that into the bills that we follow?
Well, if you're concerned about those offenses and those 3 new offenses that the bill would create, and the increase in the maximum penalty for the commission of a preparatory act from 2 to 5 years, if this is something that we want to follow there. Creation of a new sabotage offense with a maximum penalty of 10 years.
Well, it's certainly criminal justice related, so
Okay.
I think we'd include that. And the other one was in the Senate, you referenced Bill S-210 as one of the private member bills. Should we add that to our agenda as well to follow it?
That one I'm not convinced yet.
Okay.
Just because so far they just talked about age verification, how to do that, bringing in experts, who are involved in that, who have some experience in that with other types of websites, and the definition of pornography versus sexually explicit material. That part might generate some interest from the legal minds, but if it's not already there in our list there, I'm not seeing anything yet.
Okay.
No reason to follow that one yet.
Yeah, thanks, Rob. Okay, so I'll do that. I'll add C-70. I won't bother with S-210. And does anybody else have any questions or comments for Rob?
I was kind of a question. Rob, can you just elaborate? I think I missed a piece. You were talking about the May session. They're talking about victims of crime and transfers and so on. Did I catch that correctly?
Well, they weren't it was more of continuous points of order, in a partisan way I'm not sure how to describe it. It's just, I don't know, it was tactics so they weren't talking about much about the report itself. It was either to it seemed to be all about, let's say, maybe some wanted to have the report available and some don't want to have the report available. And there
Well,
seemed to be delaying and this type of thing happening at the meeting.
could you
And
remind me about this report? Because I don't quite recall.
oh,
Where did
the
it
report,
come from?
okay, so this was the study of the transfers that they were doing
Right.
regarding Bernardo, and then I think a
Right.
separate kind of study on Luca Magnotta. There's apparently a draft report somewhere or something close to that, and some members would like to see it soon, and some members seem to maybe not be as concerned about seeing it yet. And in the end, this seemed to be what the disagreement was about. And finally, they agreed that a draft report on victims of crime, reclassification, and transfer of federal offenders would be distributed immediately to the committee members. So
this
that
is an internal report, some secret document. Is that what it is?
I think the committee had a meeting about that earlier this year. At
Right.
least one they agreed to, I believe. My recollection is I think some wanted 6 and they got it down to at least 1. So there's something coming from the committee on that, like a report about on that topic. So
But this is not something we would have access to. Certainly not in the near future, right?
Not yet, anyway, because it's going.
Okay.
My understanding is it will go. The members want it's not in all the hands of all the members yet of the committee, so they would like to all have it. They agreed to share it among themselves, and after that,
Okay.
I'm not gonna guess what may happen because of all the points of order around it that were
Yeah.
happening at the meetings and all the stuff that was going on in the last on that at that meeting and one previous to that. There was some of that type of thing happening around that topic. And
Okay, but you don't know that they didn't mention or didn't come up who or what was the source of that so-called report? Like it didn't come from Corrections Canada or anything, did it?
No, I'm sorry if I completely misunderstood what you asked earlier, but I think it's the committee itself was drafting a
Okay.
report. Yeah.
Okay.
Yeah.
All right. Thank you, Rob.
Okay. Thank you.
Thanks, Irving. Thanks, Rob. Anything else for Rob? Okay, let's move on then. So next we're in the Senate, so Legal and Constitutional Affairs, and that's Brendan.
All right. Yeah. Hi, everyone. So the Standing Senate Committee on Legal and Constitutional Affairs met 6 times since the last meeting in May. 2 of those were on Bill S-15. It's not a bill that was particularly interesting, I think, to the PRC. It's a bill on at the captivity of certain large animals. The other 4, however, were on Bill C-69, which is, of course, the government's budget implementation bill. It's another omnibus bill, one of the ones that we're just such fans of. The part that is interesting, I think, for the PRC relates to new infractions for auto theft, money laundering, and things like that. So I believe I counted 3 new offenses at least. So committing auto theft in aid, or I believe that the wording was in aid of a criminal organization, which now has a maximum penalty of 14 years of imprisonment. Possessing or distribution of a device suitable for committing auto theft has a maximum penalty of 10 years of imprisonment. Then there's a new offense for laundering the proceeds of crime for the benefit of a criminal organization, which has a maximum period of imprisonment of 14 years. The bill also seeks to add aggravating factors at sentencing, specifically for adults who recruit youth or who involve, actually, I believe the wording is specifically involve youth in the commission of an offense. The bill would also make wiretap warrants and DNA orders available and easier to get to investigate these proposed offenses, so auto theft and money laundering or whatnot. There's also a division in this bill. It's Division 44 under, I think, Part 4 of this Budget Implementation Act. And it's to streamline the approval of safe injection sites by the federal government in partnership with local communities. The idea being, I think the gist of it is that it's to create a more responsive and less ad hoc way of dealing with the approval and granting of safe injection sites. So in the 4 meetings that the committee had, a plethora of witnesses were heard from Department of Justice, the CRA, various private legal practitioners, BOPP, chiefs, the Canadian Association of Chiefs of Police, National Police Federation, Criminal Lawyers Association, also from the Canadian Vehicle Manufacturers Association. There was general frustration, as there always is, from the senators about including criminal justice modifications in an omnibus bill like this. The minister stated that it was necessary due to the difficulty of passing bills in Parliament currently. I think Rob sort of touched on that with the partisan issues at SECU. There are several briefs submitted for the bill. Generally, the police are quite supportive of these measures, suggesting that it will help them tackle auto theft. Notably, actually, most of the police associations were also in favor of this new regime for safe injection sites. They were supportive of a sort of a whole, a really fulsome response to the issues of drug addiction and things like that. I don't think they were necessarily saying that they're the biggest fans of safe injection sites, but they recognize that it's a health issue that needs to be one of many options available. Now, there were quite a few concerns raised about this bill. Of course, several senators wondered why minimum mandatory penalties were not put in place for these infractions, given how pressing they are. Of course, most the lawyers on the panel, Department of Justice, responded with what we would expect, and I think matches more or less our policy position on mandatory minimum penalties, is that they don't work. They're often unconstitutional, and that it would lead to the over-incarceration, disproportionate incarceration of Indigenous and peoples, as well as other people of color. There was one, I'd say, not to go in on everything, but one thing that really stood out to me, and it didn't occur to me at first, is that the way the bill is worded in adding an aggravating factor for involving a youth in the commission of offense. I don't know if the government, if it was sloppy drafting or whatnot, but that's kind of what some of the lawyers suggested, that would now apply to any and all offenses, because it's an aggravating factor at sentencing. It's not specifically linked to auto theft, which I think was the intention of the government. But now this aggravating factor that would need to be considered for all offenses, which many lawyers thought was overbroad. There was also concerns that, of course, these new offenses are duplicative. Robbery already exists in the criminal code. In the aggravating factors at sentencing, there's already an aggravating factor for aiding a criminal organization. So they just felt that this is it's more performative. It's just going to add more work for justice and create more confusion, ultimately reducing access to justice for people. One thing also that I think is perhaps of interest to the PRC, one of the senators discussed how, if you recall, I mentioned that this bill would expand how easily wiretaps and other warrants could be obtained. Typically, the CRA has to go through the police to obtain a warrant for certain financial information. The idea is that this bill would eliminate the need to go through the police, and that CRA investigators would be able to request a wiretap directly, essentially cutting out the middleman. The idea behind it is that need to go through the police delays the investigation and can ultimately reduce the CRA's ability to actually investigate these issues. I believe it was Senator Batters actually who was concerned with how these CRA investigators would be trained because they're not necessarily law enforcement, and they would essentially be seeking wiretaps and whatnot. So there are some concern expressed there, and despite all those concerns, it seems like no amendments are going to be made because it's an omnibus bill. It seems like the committee doesn't appear to be heading the clause by clause, and I admit this is one area where it might just be my inexperience with some of the parliamentary procedures. But they said they were going to send it to a subcommittee to review, so I'm not exactly sure if that means no amendments will be made. But if that is the case, I am quite concerned, especially with that aggravating factor. So I think it's something that we should keep an eye on. But again, something I think that we should keep an eye on. And I think that's it for me, unless anybody has questions.
No, that's great, Brendan. Thank you. Is there any questions or comments for Brendan on his report? Okay, thank you. All right, so and lastly, we turn to the Senate report on human rights. Dick, please.
Well, there's been one meeting of the Human Rights Committee since our last PRC meeting. And the committee continued hearing witnesses on the, excuse me, on the topic of forced global displacement. They heard from 3 witnesses. I'll just briefly mention what they talked about. Bob Ray was the first witness representing Global Affairs Canada, and he spoke about the displacement crises in 4 areas: Sudan, Gaza, Ukraine, and Myanmar. And there are over 17 million displaced people just in those 4 areas. And he also noted that Canada is doing its share. It had the world's largest resettlement of refugees in 2023. The second witness was the chair of the Immigration and Refugee Board. And not surprisingly, there's been a huge increase in refugee claims. It's now about an 18-month delay in claims getting to a hearing. And obviously, again, more resources for the board were requested. And there was also some discussion about whether legal representation for refugees was adequate. And the last witness was the chair of the Center for Civil Liberties. This organization, by the way, received the Nobel Peace Prize in 2022, and their focus is on documenting war crimes in Ukraine. And the witness emphasized that a major problem is Russian impunity for war crimes in Ukraine and also in other countries over many years. And that's it.
Thank you, Dick. Any comments or questions for Dick? All right, thank you. That's it for the parliamentary committees. There is nothing new on the other issues on business arising. They're all waiting briefs, so we don't have to go there, which takes us to bills under consideration. There hasn't been a lot of change, but I'll just mention the bills that in fact have seen some activity. So in the Commons government bills, actually there's no activity, but on Bill C-40, which is the bill to create a miscarriage of justice review commission, I talked to member Van Popta. He's a conservative member of the Justice Committee. I've talked to him now twice with respect to moving towards 3rd reading. And I think I mentioned at the last meeting that it was going to go to 3rd reading during the week that the budget was passed, but it was put over because of budget considerations, and it hasn't advanced since then. He suggested that I talk to John Maloney, who is the liberal member of the Justice Committee, who has carried somewhat of this bill, and I've sent him a note, but I haven't heard back. But based on the premise that the summer recess is coming up quite quickly, there's really no prospect of this bill being heard or meeting for 3rd reading until the fall. So we'll just have to wait and see. And then again, for Commons bills, further to our conversation with Rob, I'll add C-70 into the agenda in that regard. On private members' bills, Bill C-270, an act to amend the criminal code on pornographic material. It's moved from 1st to 2nd reading. And on Bill C-320, an act to amend corrections and conditional release regarding disclosure of information to victims. It's moved from 1st to 2nd reading as well. And there's no other activity. Oh, I'm sorry, there is one more. Bill C-353 has likewise moved from 1st to 2nd reading. There are 3 new private members' bills. Bill C-390, basically an act to amend the criminal code to provide that medical assistance in dying may be provided under a provincial framework that allows a person who has an illness that will deprive them of the capacity to consent to care to make an advance request for such assistance. And that had first reading on May 22nd. There is Bill 391, an act to amend the Criminal Code and the Controlled Drugs and Substances Act, which amends the code to require the court to consider as an aggravating circumstance the fact that a person who was in possession of a weapon in or near a hospital, on or near hospital grounds, or in or near any other public care facility, basically, and to amend the Controlled Drugs and Substances Act to prevent the minister from granting an exemption that would result in the illicit or unprescribed use of a controlled substance in a hospital. So that had first reading on May 28th. And then Bill C-392, which is interesting to us, for those of us who follow this, it is an enactment to amend the Criminal Code to codify the analytic framework that the Supreme Court of Canada put in place in Regina, or now Rex, and Jordan regarding the right of an accused awaiting trial before a superior or provincial court to be held within a reasonable time, and to provide for exceptions to this framework. So for those of you who aren't familiar, Jordan was enacted in the Supreme Court, I think it was 2015, which was the first time the court had addressed the issue of 11B applications to set aside charges on the basis that it's taken too long to get to trial. What it did in 2015 was basically for those matters that dealt with indictable offenses in a superior court, from the time of charge to time of trial, has to be within 30 months. And for provincial court matters, it has to be within 18 months. And that was an update of the law in this regard to a case called then Regina and Moran in 1991, which amended a case called Regina and Askoff in 1989. So obviously this comes before the court on a not regular basis, but a periodic basis, basically when, for the most part, courts get clogged down with the volume of business. The cases aren't moving through the courts in somewhat of an expeditious manner, and then judges start tossing out cases, and it could be anything from theft to murder. Toss it out if in fact it doesn't get to trial in what is considered to be a reasonable period of time. So what this act is proposing to do is to codify what was done in Jordan. I don't know, I haven't read through the entire text, but it would codify, I presume, those time periods I just provided to you, which clearly is an attempt to basically put into legislature what the Supreme Court of Canada has done, over the years. Anybody have any questions on that particular point or enactment? So we'll follow that. We'll see what happens, but it's a private member's bill. So the chances that it actually turns into legislation isn't particularly promising. As far as the Senate goes, there are no government Senate bills of interest to us. On the private member's side, Bill S-212, that's Senator Kim Pate's bill that we've been following. And in fact, we submitted a brief regarding it. This is on basically allowing for charges or convictions actually to be expunged after a period of time, and basically as simply as a function of that period of time, as opposed to having to make an application to the Canadian Parole Board to basically get a record suspension, what used to be a pardon. So Howard sent a bit of a snippet of what it looked like, and I couldn't actually open it. Looked like third reading has been given to the bill. If you look at legislative information online, it still looks like it's that second reading. So, but that information isn't necessarily updated as quickly as when things take place. So we'll take it that there's third reading on Bill S-212, which for our purposes is a good thing. We support the bulk, or at least the board of the SCCGA supports the premise of basically expunging records after a certain period of time has passed. So we'll see what happens with it, on the basis that it's passed third reading in the Senate. And now will go back to the House to start with its process of first, second, and third reading before it becomes law. So at least it's progressing. So we have that, and thanks to Howard for bringing that to our attention. As far as any other Senate private members' bills, there in fact have been no changes. So there's nothing that's moved forward that is of interest to us. So does anybody have any other comments or questions regarding bills in Parliament? Okay, all right.
Miles,
Yes, Brendan.
sorry, really quick. Just 'cause I know I brought up Bill C-20 last time. It's the one that would give that would create an oversight body for the CBSA and for complaints and things like that. Just a quick update. Last night at 8 p.m. It proceeded to third reading from the report stage.
Oh, very good. All right, so that updates our. Yeah, at this point we had it as with no change, so that's.
Yeah,
very
is it
good.
fresh off the press?
All right, so that is the 10th of June. Yes.
Mhm.
Okay, we'll update that for the next meeting. Thank you very much, Brendan.
No
Any
worries.
other comments or questions regarding the bills before Parliament? Okay, so at this point, I would ask for a motion to adjourn the PRC until September, which is a pretty standard thing we do. We don't meet over July and August. If we had a motion to the next meeting being the 10th of September, the second Tuesday of that month, that'd be great. So
I can motion that.
Brendan, okay, and the second, Andrea put her hand up, so thank you. All those in favor? Thank you. All right, so our next meeting is September the 10th, at which point we'll obviously be talking about the Congress to take place the following month. So we'll bring everybody up to date on what's happening there. At least Irving can do that for us. Unless Irving, do you have anything to say about the Congress at this point?
No, we're still looking for a lot more people to sign up as participants. I have a question. Do we have a specific date? We must have, for when the House rises? I imagine it's next week.
Yeah, you know what? I looked it up and I didn't write it down, but yeah, it is next week, I believe, Irving.
Because I saw they're rushing through the tax implications of the last budget and so on. So I guess they want to get that through before they rise.
Yes, that's fair.
All right. Thank you,
All right,
Miles.
guys.
Have
All
a good summer, folks.
Yeah, thank you very much, everybody. Again, have a
Thanks,
wonderful
everyone.
summer. All right, and we'll see you in the fall.
Take care. Be well. Bye-bye.
Bye now.
Bye.